All right. Hi, listeners. This is episode 4 of The Elephant in the Room, the podcast. I'm your host, Natalie Hanson. And today I'm joined with a very special guest, Ashley Fritz. But before we get into the questions, I do want to put out just a quick trigger warning. This podcast is focusing on the concept of sexual assault. And as a survivor myself, I completely understand how much weight this topic holds and how triggering it can be at times. And if at any time during the podcast you feel the need to stop listening, I fully understand. And I also want to point out that I will verbally read each question during this interview. So if certain aspects we discuss are triggering in any way, please feel free to skip past those questions. My number one priority is to make sure that all participants in this podcast and every listener is comfortable and feels supported. So with that being said, I will turn it over to Ashley. Ashley, would you mind introducing yourself?
Absolutely. So I'm Ashley Fritz. I'm the Assistant Dean of Students in the Dean of Students office here at UW-Eau Claire. My primary role on campus is doing student conduct. So on or off campus, students get up to things and that I'm the person that they meet with. Another role that I fulfill on campus is I am one of our deputy Title IX coordinators and a Title IX investigator. So when students report sexual assault, harassment, dating violence, stalking, things like that, I'm one of the primary people who investigate that when it happens between students or when it happens to a student involving a non-student. I'm basically the main point of contact on our campus for things like that. I've been at UW-Eau Claire for almost, I think it'll be 3 years this summer. But I've been working in this field since 2013 and as a conduct officer since 2010.
With that being said, we'll get into the questions. So first question, how would you define sexual assault, and is there an established university definition?
Yes, there are actually very specific established university definitions. Every school in the UW system, so Eau Claire, Whitewater, Stout, River Falls, all of us use the same definitions and the same policies. And so for us, within what we call UWS Chapter 17, which is non-academic misconduct, there are very specific definitions and they're based on state statute. So we use almost the exact same definitions as the state of Wisconsin. We have a little bit of wiggle room in some policies, not necessarily how those behaviors are defined, but in over jurisdiction and how we define consent and things like that is more specific within the university than it is within the state. Even in our own records, we classify like first degree sexual assault, second degree, third degree, fourth degree. Like we use those same classifications because we're asked to report them.
Okay.
So we have to record our data at that same classification system, which can be difficult because it means that I can talk to a student and know that something happened that shouldn't have, but I'm also bound by these definitions. And it means that it doesn't mean a definition. That doesn't mean that I can't still help you or support you.
Right. Second question, how would you define consent, and is there an established university definition of that as well?
Yes, actually the definition of the consent that we're currently using is new per changes from the Department of Education at the federal level. We had to pass something called Emergency Rule 2027 that has actually modified our definition of consent as we use it because it did change some of our definitions. It changed our process consistently, but what it basically means is that consent as they define it is overt words or actions by a person who is competent to give informed consent, indicating a freely given agreement to engage in sexual activity or other conduct as defined in this code. A person is unable to give consent if they are incapacitated because of drugs, alcohol, physical or intellectual disability, or unconsciousness. Okay. Which is a much better definition than the state's definition. And as much as I'm not actually a super fan of the emergency rule, that's one of the best parts of it. It's a much clearer definition than we've been using in the past.
Okay, so say a survivor is unsure if they want to file a report, would they be able to go to the Dean of Students to provide the survivor with any possible options that they could take when they were sexually assaulted?
Yes and no. We have obligations when it comes to student and campus safety that sometimes can't be worked around. Like I have met with students where they tell me something happened to them and I have to record that. I have to report it for our data. And I can tell them here's various ways things might play out. But sometimes I also might figure out who they're talking about. And then I have an obligation to move forward. So that's why I think we are extremely lucky to have confidential resources like CASA and actually also our student counseling staff, because we train our student counseling staff. We work with CASA all the time. I think I probably talk to Grace at least once a week, and the people, her predecessors, at least once a week. There are people we work with really closely who know our process, know what our office is like. They can kind of be an intermediary of like, I have this student, this is their situation. What do you think? What are our options? And they can keep that student, in control of their narrative and in control of what they want to do without sort of triggering some of those safety measures that we're obligated to put in place.
Does the survivor have to report the name of the assailant when reporting? And would the accused be informed about the survivor's identity?
It depends on what we're doing with the process. So if someone comes to me and says, this happened to me, and this is, when this is what I need, and what they want is for, they want to change to a different class or move to a different residence hall, or, they want resources or they need time off or something like that. If I don't know the respondent's name, there's not a whole lot I can do. If I'm working with a survivor and the survivor wants something for them, it's much more straightforward. There are times where I have known the name of a respondent, but I don't know enough information to open an investigation. And if that's the case, then no, the respondent is not informed. If we are proceeding where I need to take action that will impact the respondent, so if I need to move the respondent out of a residence hall or out of a class or things like that, yes, we do have to tell them the name of the person, because if we're doing that, we're following all the way through with an investigation.
If a survivor was worried about retaliation or harassment from the accused friends or other peers, or the accused themselves, what sort of protection could the survivor receive?
They're sort of twofold. We do preventative measures, which are called interim measures. So we put no contact orders in place. We remind students that they can file for restraining orders, and you can file for a restraining or a protective order without having to file a police report, which I think a lot of people don't know. That is another big role that CASA plays on our campus, is that they help students maneuver the legal system. They've helped many students do that without them necessarily going down the law enforcement or criminal route. We move students, we ban people from buildings, we set schedules if we need to. Like, these are the hours where I had one case where both of them were like fitness junkies, and I had to very specifically state what hours on what days which student could be in McPhee. So we will do things like that. So it's sort of the preventative measures to keep students away from each other. Now, given we are a small campus, so we have what's called incidental contact. You might be in Davies at the same time purely by accident. As long as no one interacts, okay, just walk away. In terms of if something happens from somebody after a person is reported, that becomes its own conduct violation. I always warn parties on both sides, actually, like, your friends need to be there for you. Don't let them worry about the other person, because if friends of a respondent or a girlfriend, not at this institution, but at a previous one, I had a parent, if it's a parent, I can report that's a crime. I can report them. That's harassment. So that's kind of easy. But when it's another student, like, it becomes their own conduct record, and it's a pretty severe outcome, because retaliation and forbidding retaliation is requested of us at a federal level.
Okay.
And usually if I have a student who violates a contact restriction, even if they weren't facing a suspension, they probably are now, because that means that they knew a university directive and intentionally violated it. So there's pretty severe outcomes for violating the barriers that we put in place.
Yeah.
And with the students are warned at least 3 times in our process about retaliation and what that looks like and what we mean by that. And I talk to them about it whenever I meet with them, of knowing, like, your friends need to focus on you. They can be mad at this other person, but, like, they can't interact, because even if they're not doing, like, say a respondent's friend approaches a complainant and says or does something, it doesn't matter that they didn't do it at the request of the respondent. They're still in trouble. That's still a problem and shouldn't be happening. So we're still going to respond. It happens a lot more rarely than people think.
Right.
Because I think once our office is involved and we have these very formal letters that everyone receives, and we talk about consequences, and we're very clear in these letters about what's going to happen, people back off. They're scared. They know that it's a big deal. And so most people do not want to get in the middle of something that they shouldn't be involved in.
You were saying that they could file a restraining order or the no contact request without having to file a police report. So would they do that through the university, or would that be through the university police? Or
if it's between students on campus, they can do it through university police if they want to file a police report. Otherwise, I always suggest students work with CASA, because it's literally just like a document you fill out and you take to the courthouse, and then a judge approves it or not.
Oh, okay.
And there's a temporary, and then I think within 30 days they have an actual hearing, and they can put a one in place for our 1 to 4 years.
Okay, that's good to know.
Yeah, that's another kind of the bonus of CASA. And, a lot of our judges understand, generally, because I hear a lot about our judges from other conduct issues, but they do understand, like, college students and concerns, and hear people out for those specific concerns. Also, we have a housing department that has no problem banning people from housing. So we've definitely had cases where one person lived in housing and one person did not, and housing is like, I don't care if they have no other reason to be here, banned. from every residence hall, not just the person's residence hall either.
So can a survivor file a report with the university and the university police, or do they have the option to report to just one and not the other?
You have the option to report to the university, but not the police.
Okay.
If you report to university police, we're going to find out about it. But no, if you report to us, we are not obligated to tell law enforcement unless we think there is an imminent safety threat.
Okay.
But otherwise, the only way our police really become aware of it is when we're going over data things. It's like when we're reconciling our Clery report, the police chief is a part of that. So he's aware of cases, but they won't open investigations or do anything.
What should a survivor do about preserving evidence of sexual assault if that were to happen to them?
Oh, that's a hard one. When it comes to physical evidence, I think, that's not something the university can deal with necessarily. We don't have a lab. We can't do DNA testing. There's a lot of advice out there from a criminal perspective of like, take off your clothes, put them in a brown paper bag, seal the paper bag. I actually think it's part of our Clery report that actually runs through that as well. Okay. In terms of your digital evidence, which is a huge part of investigations these days, if you're going to block someone, take screenshots first.
Sure. Yeah.
Like if you've saved your Snapchat conversations, Snapchat is the bane of my existence. It was so much easier when everybody texted.
Right.
There was a record then. And even though I know Snapchat sends a record of your screenshots, I don't care. Or you have a friend take a picture of your phone.
Yeah.
Even if you don't know if you want to report right away or it's going to be a while, but you want to block this person and you're worried, take those pictures, take those screenshots, keep that stuff, because that's often what provides a lot of clarity in communications or, catches people in dishonesty is like, well, you said this in a message.
Your actions versus your words, they're not really matching up. So that makes sense.
Yeah. So I think digitally, it's like, if you're not sure you want to report, but you think sometime you might, but you're going to block somebody, preserve your digital information. I've had cases where students were not comfortable having that on their own phone because it was very triggering or uncomfortable. And so they gave the information to a trusted friend.
Sure.
I was like, here's the pictures on this thumb drive. Just hold on to it for me if I change my mind. You have to remember that the majority of sexual assaults occur between people who know each other. So you're going to have a history of messages or interactions, and all of those are very telling.
If a student were to disclose to the dean of students that they were sexually assaulted off campus, can the dean of students investigate, and how would that work?
If the person they're reporting is another student, yes, we can.
Okay.
If the person they're reporting is not a student, a lot of what we can offer at that point, if they don't want to report to police, is basically support services. Okay. We can also, if we feel like there's an ongoing issue between them, we can sometimes ban that student from campus, which takes a bit. We can do a no contact order in a day. To ban someone from campus because we're a public institution takes like a week. We have to run it through attorneys, the police department, all of that stuff. But yeah, we have jurisdiction over off-campus behavior for everything, not just sexual assault, but for everything. If you look at chapter 17, it's 1708. It's literally about non-academic conduct that takes place outside of university lands. Basically, it says that if anything impacts our, mission of teaching, research, and learning, which it absolutely does, we have jurisdiction to investigate.
What parties would be involved when determining sanctions?
Well, under the emergency rule, the first phase of a decision is with the investigator. So I would make, if it's me, I would make a recommended outcome. So recommended finding of responsible or not responsible. And then based on our precedent and sort of some kind of standards we've created, based on this behavior and the behavior in the case, this is our outcome. Currently, all cases automatically go to a hearing, no matter the outcome that's recommended, unless the students agree not to move forward, which almost never happens. Everybody goes to a hearing. And at that point, the hearing examiner or hearing committee would make a determination and have final say on sanctions. They would, however, have to consult with the dean of students office, because if we go outside, I hope everybody's familiar with the term precedent, but it's like we have sort of standard outcomes for certain things, which there's absolutely flexibility as long as we have a rationale for it. So if we're doing something that seems, way more severe or way lighter than we would normally do in a case with these details, why are we doing that?
Sure.
And some of those factors would be, if we have a respondent who's really apologetic and understands how they impacted another person, and the complainant says, I don't want them suspended, I just want them to stay away from me, I feel like they've been genuine, we might not suspend somebody, or we might say it doesn't matter that they're sorry, the behavior is severe enough, suspension is the only possible outcome.
Sure.
If we have a student who, in addition to what they're accused of, they violated a contact restriction, or we had a student who tried to tell a witness not to testify or not to talk to us or things like that, where they're also disrupting the process, we might go from a student who maybe was only going to be on probation or only suspended for a semester to suspension for a year. So it's things like that would impact the outcome.
Yeah.
We can take a complainant's feelings into account,
Sure.
but that's one of the factors set up against precedent.
Is it possible for the university to give the survivor a sort of time frame to follow during the process, or does it vary?
It varies by case. I would say at a minimum 6 weeks, and that's without the hearing, because the emergency rule has very specific timelines. So usually I do 2 meetings with the complainant. We do our very first meeting is talking about the process and answering any questions. It's very overwhelming. It's a huge information dump. Then I have to give notice to the respondent, and they have to have what the policy says is enough time to prepare, which is usually about 5 days. If they have to rearrange any schedules, if they want an advisor with them, that gives them time to do that. Then I have to interview everybody's witnesses, which can take time because students, when their witnesses are not always super responsive, it's not always a priority. Then when I finish a drafted report, I have to give them 10 calendar days to respond to that report. And then, it's writing an outcome, sending that outcome to both students, and then scheduling the hearing. And it's usually about a week and a half to 2 weeks to schedule a hearing, because we're looking at a minimum of 6 people's schedules to get 1 2-hour window together, and then they have 10 days from the outcome of the hearing to make a decision or to issue a decision.
I mean, obviously, like you said, it varies, but on average, probably about that 6-week time period.
Right. And there are some cases where, if we have stalking cases that have gone on for a while, or if the students were previously in a relationships and things have gotten complicated and we're looking at months of information or multiple witnesses, I mean, that everything where there's more people and more information to process, it's going to take longer.
Sure.
We had one case that just because the sheer amount of human beings involved and that more and more evidence just kept coming into our office, I went on a 3-month maternity leave and I came back and we still weren't done because there was just so much in that case.
Right.
And in that one, we actually entered into something called a settlement agreement, which is very unique to Wisconsin. I've never had another school that did this and actually codified it this way, but where a respondent could look at a case and be like, this isn't going to go well for me. And I don't want to go to a hearing. How can we reach an agreement where, where this is just done? It also is for students who maybe have a concurrent criminal case going on where they can say, I'm not going to say that I did it, but just give me the consequences and let me go.
Yeah.
So those are things we do where the complainant also has to agree to the outcome, but often it's usually they're going to leave right now. They're like, great, let's do that.
If there's more people involved, more parties involved in the case, that's going to take a lot of time to find time to meet with all of those people, get information from all of them and everything. And I'm sure that can be overwhelming for that too, because there's probably so many different pieces of information coming together. Who would be present at a disciplinary hearing if the university took action, and who generally is present at a university disciplinary hearing?
Sure. So if I was going to go the max amount of people we would have, it's at the university's discretion whether we have a single hearing examiner or a committee. Generally, with sexual assault cases, we use a hearing examiner because they are our most experienced faculty or staff. They've worked with us the longest. A lot of those are senior faculty and our associate deans and things like that. If for some reason we would go to a committee, that committee will never have students on it. If we ever did a committee, it'd probably be 3 faculty and staff, never any students. As much as I value students' perspective on these issues, it can be really traumatizing. And if you are not in a place yet to be able to compartmentalize that experience, it's so not healthy for you. And it's not, it's a decision that's a really big deal and can be really heavy. And, you don't want to make the wrong call, and we're not going to put that pressure on you. But most of the time it's a hearing examiner. So there's one sole person that everyone's making their case to. Then there would be the complainant and their support person and their advisor, the dean of student staff member who investigated, the respondent and their support person or advisor. And then we also have another dean of student staff member present just to make sure we're following everything procedurally. And if there are any procedural questions, that's their role. They have no decision-making authority. They're literally just there to administrate. Are we following the procedure? Are we following what we're supposed to be doing with rules? And then they're the person who does all of the administrative tasks for the outcome, because most of our faculty don't have access to the database we use
Right.
and wouldn't know how to use it because it's so infrequent for them. Whereas for us, it's like, I've been on there all day today.
Yeah.
So they're basically the people who are like, put this all in the system, send out the letters, make sure all the data is there, that kind of stuff. But generally that's who would be there. It does feel like a lot of people. However, one of the benefits of the pandemic is us all realizing that hearings are so much easier to have in an online environment.
Yeah, for sure.
Like trying, even in cases that were not this, so like another non-academic case where it's like a student and a faculty member or just a student, there is no conference room on this campus that is comfortable to have a hearing.
Right.
It is an uncomfortable situation no matter what the hearing is about.
Right.
The digital environment has opened up so much. All of our hearings have to be recorded by law.
Yeah.
So recording in a digital environment is fantastic.
Yeah.
But also everyone can be in a space where they are like safe and comfortable and private and can feel supported, and like it's so much nicer. And then we don't have to have a respondent and a complainant in the same room. It's so much less confrontational of an experience.
Right.
It feels a lot less crowded, even though that is a lot of people.
Sure.
We've been doing hearings online since I think the first one we did was like May or June 2020. And I was like, I'm never going back. As the person who organizes most of our hearings, I'm never going back. This is amazing.
Yeah.
And most of the hearings we've had this year have been academic related, not non-academic.
Sure.
It's so much nicer for everyone. Everyone can just be in the space where they feel like they can talk and they're more comfortable, and that they feel like they can express themselves to the other people in the room without having to be like right in each other's faces. And it's so much nicer.
Yeah. With the virtual meetings, I was like, that's the first thing I thought of. Is I feel like for some people it would feel so much more, I guess, uncomfortable, or they would be like less triggered, not being in the room with them. I know that makes a huge difference. So
yeah, it's one of those things where I came into one of our staff meetings and I was like, listen, someday we're all going to be back in person. This is going to stay the same.
Yeah.
Because also trying to find a room where we can fit everybody and like physically moving recording equipment into that room is just stupid.
Yeah. Just a lot.
I mean, literally, the last hearing I had was on Zoom. I recorded it on Zoom. It uploaded to a cloud. It downloaded to my computer. I had it in our file and sent to who needed to have it within an hour.
So
I mean, it would take like days to do that with our old recording equipment.
Yeah, I bet that's so much quicker, so much less time consuming, I guess.
And it's just so much less confrontational. I even feel that way about everything we've done since things moved digital. Like I feel like anytime I'm meeting with a student who's been in trouble for anything, things are just softened like this. And I don't know why that is, but I feel like students are more likely to show up for meetings. I've had much less missed or skipped meetings. Our expectations have lowered, but it's also, I think, opened up communication in a really positive way, or just made it less confrontational and more conversational.
Absolutely. So regarding like any training, do students, faculty, and staff all take part in the same training regarding sexual assault?
Students do one kind of training.
Right.
Every incoming and transfer student has to do the program, and every student gets the opportunity to do it again every year.
Okay.
As well as, vast programming we have across the year. Right. Faculty and staff are all required to do something that comes from system that we have to do every year. That goes over not just definitions of like, this is how we define things, this is our expectations, but also like expectations in the workplace.
Sure.
As well as if someone tells you something, this is your expectation for reporting. Right. So they go through something that's much more formal and expectations based.
Okay, well, that was the last question. So Ashley, again, I cannot thank you enough for taking the time to be a part of this podcast. Do you have any other like closing comments you would like to add? Or
I think coming back to the first question about our definitions is, and I always try and tell every student who reports this, is that these are the definitions I work from, and we might talk about something and no, it doesn't meet the definition. I'm not going to be able to move forward with a disciplinary case. I still have the ability to separate students. We also have some informal processes that are sometimes appropriate. We can do mediation. The dean does that himself of, you did something that impacted me, something that hurt me. Right. I don't want you to do this to somebody else, and hoping that the other person genuinely hears you. Yeah. We haven't done that a lot, but every time we have, it's been fairly successful. Yeah. I also like to remind students that like we might go through a whole process, and at the end of the day, the person's found not responsible. Even in that case, I can still keep separation measures in place. Like as our students were basically saying, like, there's drama between the two of you. There's an issue between the two of you. There's no reason that you should want to talk to this person when this is
Right.
over.
Right.
So even if I can't, hold someone accountable the way that we would hope or the way someone would want, I can still take measures, hopefully, that make someone feel safe and like they can still engage in their education in their community.
Yeah.
So, it doesn't always work out the way you want at the end of the day, but that doesn't mean there isn't still actions we can take. If we get to the end of a case and there's, we're finding a respondent not responsible, we still tell them you are still to have no contact with the complainant. The
Right.
complainant's not to have contact with you. If you do, it becomes its own separate violation of the code. It's not like we reopen the old case, it becomes its own new case.
Sure.
Because we have reasonable requests of a university official. If you violate that becomes its own code violation. And if it happens a lot, it becomes harassment or stalking, and then we have a whole new case anyway. I would also let everyone know that while I think our bar by the state law is very high for sexual assault, it's actually fairly low for harassment and stalking. So if you feel like someone is not leaving you alone, if they are bothering you, you probably have more recourse legally than you think you do.
Sure.
I think, all of these issues are underreported, but stalking in particular,
Right.
Especially when we live in such a digital age where it's easy to access one another. We're just like, oh, this is just a thing that happens on the internet. Like, no, that should not be the standard by which we live.
All the information you provided is all new things I've learned, and I'm sure a bunch of people will learn a lot too. So
I hope so. And like, we're not saying it's a perfect process by any means. We're not saying that it works every time because, ultimately these are unfortunately intimate incidents where there is only two people in a room, and it is really difficult to prove something. And just because I can't prove it doesn't mean I don't believe it or I'm not going to be supportive.
right.
It just means I can't use an university process to do something about it.
Well, I appreciate all of the information you provided me with. And again, thank you so, so much for being a part of this podcast. I know it's been a crazy time, so I really appreciate it. And with that being said, that's another episode of The Elephant in the Room. I'm your host, Natalie Hanson, signing off.